All right. Well, thanks for everyone for coming back together so promptly. My name is Josh Mitz. I teach here at Columbia Law School, securities, corporations, corporate finance. It's a real pleasure to be with you this afternoon and to introduce our last panel. The topic will be regulatory restraints on investor voice. And we are joined here. I'll just introduce very briefly our panelists: John Coates from Harvard Law School, Eric Girding from Freshfields, Ali Rutherford from PJT Camberview, Bob McCormick from CII, and Drew Hambley from CalPERS. And we're going to basically have Professor Coates shortly here kick us off with some general thoughts on regulatory restraints on investor voice, and then hopefully begin what will be an interesting discussion of some emerging issues and recent developments. So, Professor, the floor is yours.
Thank you. Let me begin with to echo the themes you've heard from earlier today about the person we're honoring, whose role in the profession was at its peak when I entered the profession. And so I thought of him as up there on Mount Olympus with other gods like Marty Lipton at Wachtell, where I worked, and Joe Flum and the like. And I actually, at the time, even many years after I came to have met him and worked with him, I was still too young to really appreciate how influential he was. His work on corporate governance through global organizations is the kind of thing that was happening in place in the early 90s that completely changed, in my estimation, the way boards of directors of every American company function, and did it without headlines and without major lawsuits and without formal legislation, and to be able to be the impresario, the leader of that movement, to make the board of directors an effective part of corporate governance with virtually no flashpoints is just an astonishing thing to look back on and to reflect on that contribution from our Millstein's career. I will say, too, just to echo, there's so many things in the prior panels that I completely disagree with, but I won't chew up this panel's time saying them, with one exception, because it links to Ira. Towards the end of my time at Wachtell, I worked on Trump's first bankruptcy. And while Gottschall was representing the bank group that took away some of his toys, one of which was the Trump airline, the shuttle flying up and down the East Coast, and we represented, at Wachtell, we represented US Air, which, of course, like most airlines, has no money, and so couldn't just buy it from the banks. They had to be an elaborate 10-year, 5-volume contract that we negotiated that chewed up the better part of a year and a half. All right, I tell you that war story because right in the middle of it, we realized that the agreements we were negotiating, and we brought Ira in to consult on this, he had to tell his bank lending partner colleagues were illegal under Delaware law because they had a molus problem. They actually, they tried to take away from the entity that the airline was going to be functioning through 141A powers and give them to some complicated division of the airline, the bank, the junior bank group, and all that. It's just not going to work, he said. We got to rethink this whole thing. And so, contra Bill Savitt's suggestion earlier today that somehow is a shocking new development in the evolution of corporate law, Ira Millstein, circa 1994, completely different perspective on that. So, maybe times have changed. And anyway, all right. So much for my encomium to Ira, and I'll move on to our topic. So I'm going to kind of just give a high-level overview of why some of the issues that we're going to be talking about, I think, come up, and how they are a little bit different from each other, even though they all are fairly within the same legal bucket. So the question is, investor regulation in the corporate governance system, why is it more fraught today? Why is it repeatedly coming up in a bunch of different places? Part of the reason for that is because the investor community has changed. It's changed in good ways, in the sense that they are far more attentive to the responsibilities as stewards of other people's money in the corporate governance world than they were in, say, 1980. But it's also in part because of some basic economies of scale and the fact that it's really hard to beat the market. And you put those two things together and you get an increase, massive increase in the concentration of assets in four complexes, Fidelity, BlackRock, State Street, and Vanguard. And then once you've got their concentration and you've got them talking to each other regularly about corporate governance issues, then even others in other parallel groups, including some represented on this panel, you've got a fairly different kind of corporate governance investor level interaction with boards and with companies than we've ever had before in our history. Right? They're just objectively, whether they like it or not, more powerful than they used to be. And therefore, the thought of regulating them regularly occurs to all kinds of people for all kinds of reasons. Now, I'm going to organize really briefly different reasons for thinking about regulating owners and then turn it over to the group, because I think different parts of what we're going to hear sort of fit into different reasons. First, and maybe sort of the most straightforward for academics, is the same kinds of agency problems that manifest at the company level that can make the leader of a public company diverge from shareholder interests to pursue their own private interests. They can also manifest at the level of an institutional investor. You can have an institutional investor whose managers might have slightly different views than their investors' views about any given topic. So you've got straightforward agency problems now just at that level, and that's a long-standing potential problem. We heavily regulate certain kinds of institutional investors for this reason, but there's always new and emerging ways in which agency problems at that level can show up. So that's one reason you might think about regulation of owners. A second reason is actually at the company level. Again, as large owners, they potentially can become effectively really controllers, actual controllers of a publicly held company. And all the other investors in that company, at a minimum, ought to know about who they are. So we have tripwires, 13D, and other disclosure requirements at the company level that is designed to minimize the risk that the institutional owners, as controllers, can affect their public company. And then you get into debates about not wanting to overly deter owners from taking control or at least influential positions versus making sure everybody's aware as early as seems reasonable about their presence and ability to influence. So that's a second type, right? You got agency problems at the owner level, agency problems at the company level. Then you get to sort of a completely different kind of reason, which has nothing really to do directly with corporate governance. It has to do with the nature of the businesses in which they're investing. Some businesses so affect the public interest that we have regulation of control of those businesses. Banks are heavily regulated. Control of banks is heavily regulated. Control of public utilities, defense companies, telecom companies, insurance companies, go down the list. If you acquire control of a major company in any of those sectors, you've got to go through a regulatory process. You have to comply with regulatory obligations. And so now we think about ordinary public companies of a variety of kinds. As big institutional owners get bigger and more influential, they start to test where exactly do we want to kick in those socially or public prophylactic regulatory regimes. In an era when most shareholders only held less than 1%, those regimes were only typically tested when there was a total takeover of the whole company. Now, with the rise of very large institutional blocks, we're having to ask on a much more routine basis, should the FDIC get in the way of Vanguard owning more than 10% of a bank? And if so, how should they get in the way, and what sorts of things might kick in because of that. Same with public utilities, same with defense companies, same with insurance companies, every other sector that we use control regulation to stand in for public protection. And that's obviously a very different kind of thing than agency problems at the company level, agency problems at the institutional owner level. And so with that roadmap, I'm now going to turn it over to the rest of the panel to talk at a much more fine-grained level about this.
Thank you, Professor Coates. Let's get forward here. So, I mean, it's great that you were talking a bit about investor ownership disclosure, because in fact, our first substantive topic is 13D and 13G. Bob, do you want to start us off with an overview of where we are, and then we can get the rest of the panel discussing this?
Sure.
Yeah.
Nothing's more exciting than talking about 13D, 13G late on a Friday. So I think that's why we scheduled this now.
Just wait till we get to executive compensation.
Yes. So kind of building a little bit off of what Professor Coates was describing. Historically, there's been great dialogue between investors, particularly the largest investors, and public companies. And that has really grown over the years. I would say mostly spurred on by this advent of say-on-pay, 13 or 14 years ago. But it quickly morphed into a much broader discussion of lots of different issues, directors, E&S issues, et cetera. So that process had been very effective in encouraging the dialogue, like I said, but also encouraging mutual understanding between companies and investors. And I would say the system had worked pretty well over the years in terms of ensuring a high level of understanding, rapport, and frankly, ultimately support by shareholders of public companies on a lot of issues, and companies' responsiveness to investors on those issues. There was, in February, the SEC staff changed their guidance on when companies can take advantage of the less onerous 13G filing if they engage with companies. So briefly, companies, shareholders who buy more than 5% of a company have to file 13D, kind of what John was talking about in terms of the notification to other shareholders. Passive shareholders, and that is not intended to mean index funds, but more large institutional investors who were not intending on exerting control, were able to take advantage of the 13G filing, which was less onerous, less frequent, et cetera. So less of a burden. The new guidance basically indicated that if an investor who is a 13G filer engages with a company and basically conditions the discussion or their action by the company on a director vote, even implicitly, then they would lose that 13G status and have to file a 13D. It's pretty arcane, but the upshot was initially most large investors took a pause from their engagements. Almost immediately restarted, starting with a disclaimer, basically saying they were not going to engage with the intention of exerting control. The upshot is the engagements themselves have become a bit more routine. They cannot have really any discussions around director voting. They have become less frequent. The engagements that were driven by investors in terms of calling companies if they had a question, those have really fallen off. The engagements themselves have become a lot less constructive because the investors, whereas in the past they would provide even an agenda of what they wanted to talk about, maybe help the company figure out, do I need to bring my comp expert? Do I need to bring a member of the board? There's a lot less of that sort of agenda setting beforehand, which means that companies go into these engagements really not knowing what questions they may need to almost anticipate that the investor would have asked, but with the advent of the new rule can no longer ask. So it's led to fewer engagements, less fruitful engagements, and for the companies, potentially lower votes on certain items. So for example, to be very specific, say a investor is looking at a proxy statement and a director has less than 75% attendance. Typical policy for most investors that they would vote against that director for poor attendance. Equally frequent occurrence was an investor to call a company and find out why that attendance happened, or during a typical engagement that would come up. Could be a new director, joined a board, she didn't step off her other boards, et cetera, health issues, et cetera. And those conversations could result in the investor saying, all right, well, that's a plausible reason, we're going to vote for in this case. Those conversations can happen. And then just lastly, and probably most importantly for the public companies, in a particularly contested situation, the investor is precluded from, in effect, talking to the company because it's inherently about the vote on directors, right? A proxy contest. But they can talk to the activist, the dissident, putting the company at a major disadvantage of the messaging. So this has probably been a lot of unintended consequences from the adoption of this rule. And, you know, in talking to people who have engaged with SEC, it doesn't seem like there was a lot of discussion with either investors or companies, the two parties impacted most by this new rulemaking.
Maybe I'll
Oh,
just,
you wanna-
yeah, I'll just jump in. So I mean, maybe a couple of things that add to that. So in practically speaking, right? So this is impacting investors who own more than 5% of a company. But a lot of investors in some portion of their portfolio own more than 5%. So some investors have taken the approach of consistency across all of their investments and how they're approaching the engagements. Others who you know, are kind of taking a more nuanced approach, and if the position is above 5%, maybe more careful, and if it's below 5%, not. Obviously, for the large index funds, Vanguard and BlackRock, most of their investments, over 95%, have more than a 5% holding. Interestingly, State Street is less than 50% of its holdings, above 50%. And then you get to your actives, and that's a very nuanced situation. And one other sort of maybe unintended consequence, not sure, is that this isn't just about governance engagement. You know, if you think about a portfolio manager engaging with a company in normal course around the position on the performance of the company. I mean, implicitly, they are talking about their vote on a director. So I think the way that this is being interpreted by investors is you know, very holistic and really taking a step back. I think the timing of this is interesting too, right? We're heading into proxy season. So that like step back that Bob mentioned, the pause, and then the restart of engagement was a little bit around how do we handle this in the middle of proxy season? What we haven't really had to deal with yet is how do we handle that outside of proxy season when a company is responding to a low vote? You know, 90% of companies, of S&P 500 companies, more than 90% report that they engage. More than about 60% directors are actually doing this engagement. So having a director take the time to go in, talking to an investor, and it's in what I think a lot of people are describing as listen first mode. So a lot less dialogue, very different than what we've historically seen. Companies have spent a lot of time building these relationships, trusted relationships where they can go and say, look, we have an issue. We're trying to figure out how to navigate this. Maybe it's an activist. Maybe it's responding to a low say on pay vote. And they're really leveraging the relationships that they've established over a number of years to get that. And I think this dialogue between companies and investors has really shifted. And my last point, and maybe this is a good way for Drew to jump in, is, you know, there are other investors that this does not impact. So I think, you know, like CalPERS, for example, I think maybe has fewer than 5 positions above 5%.
Yeah, I'm not sure.
If
about
any.
that, yeah.
I think it's actually 2, but you know, so I think so the voice of certain investors may be louder in these engagements when companies continue to have them, and maybe a little bit outsized relative to the way it was prior to this new guidance.
Yeah, thanks. And I'll just add to this. So Drew Hambley from CalPERS. So, you know, I suppose the benefit to us has been companies want to talk to their investors, and we don't just talk about votes. We talk about capital allocation policy, you know, policies that companies have. And for us, our portfolio is constructed in such a way that we're generally not more than 20, 25 basis points in any single name. And then we get to have these great discussions. And so our engagement program is expanded over the last couple of months, and we're still trying to figure out like who really wanted this because it's not benefiting investors, not benefiting the companies we invest in. And I'm really not sure who the beneficiary of this new rule was. But for us, it's been great because, as Ali pointed out, our voice is getting heard, and we're getting lots of calls because companies do need to hear from a variety of shareholders so they can triangulate on, what their strategy might be.
Can I jump in for one minute? I do think that what you've said in terms of the challenges for the issuers is very much true. This is a challenging environment for issuers who want to engage with their shareholders. You don't want to walk into a meeting with shareholders and just have it be a staring contest. And the problem with this kind of uncertainty in terms of how the guidance works is issuers now have to really anticipate what questions they think investors are going to have. So it becomes more like a French mannerist play, right? Where you're reading eyebrow raises and that's challenging for issuers and our clients. We're looking to really have that kind of constructive dialogue. There are some people, some commentators out there who speculate that this is really about ESG investment specifically. So we'll just throw that out there as a potential reason for this particular guidance.
I think that's fair. The examples that were provided in the guidance, though, were actually not on they were executive compensation, classified board. So I think that's added some uncertainty to the back and forth. So I don't know how you're navigating that in the questions. I don't disagree with you. I think that was the intention, but potentially the intention of at least some, but the actual, perhaps you want to jump in?
Can I just, so make sure I summarize the takeaway. So the early Trump informal rulemaking has empowered CalPERS, has empowered probably, although they're not on the panel, ISS and Glass Lewis, because they don't own blocks of stock, so they're not affected by 13D directly. Has empowered probably CII, because you two don't directly own stock. You are a voice for people who might, but right. So I just want to note for the record, the outcome of the non-engagement that staff had with the public before changing the rules.
Yeah, I think I'll go with that. I think that perspective is overstated in terms of empowering either CII or the proxy advisors. It's not their votes, it's their clients' votes or our members' votes.
No, but all right, I can't help but argue. If BlackRock can't talk, and if Vanguard can't talk, and if State Street can't talk, and if Fidelity can't talk, and another big active T. Rowe can't talk for a given name, and the company needs information about how investors generally are going to be functioning, they got to go through intermediaries. And I think over time, well, and I predict if it hasn't happened yet, Bob, it's going to be coming more and more your way, because you are in a position to gather information from investors in a way that is not going to trigger 13D concerns, right? So
I don't know.
Yeah, but it's not specific to any one company, John. And we'll talk about policies in general, but
okay.
If that would have happened, it would have already happened in some instances, but just because of the shift. But keep in mind, all these people have their own policies. BlackRock's got 70 people on their staff. They're not following anyone's guidelines or recommendations. They're following their own. And if the intermediaries are allies and the proxy solicitors who have the insight into how investors look at these sorts of things, but it disintermediates the shareholder, which is the worst thing that you can do.
First of all, just to clarify, there is no such thing as an alley. There's not an. I'm just a person that's.
Alley's farm.
I think one of just to be a little bit careful on that point. This was earlier change in guidance, I think last fall, maybe before that, but this is not just a one investor at 5%. It's also collective.
Yep.
So I think Bob and CII probably also needs to be a little bit careful in how they would be the voice of certain investors. Obviously, there's a lot of nuance to that, but I think there is some thought around how one would go about that. Look, I mentioned the stat on the number of companies that disclose long-term governance-focused engagement. We'll put ESG in that same category of governance. I think the benefit of that companies have right now, I don't know how long this will last, is they know they've had plenty of conversations. This is not just a one and done. This is a long-term relationship building exercise. So I think going into an engagement, there is a level of understanding of what each investor's, perspective is. It's been shared over a number of years. So I think, for right now, that's the case. The area where I think we've seen the greatest impact is the transparency. Companies, we advise companies on engagement with investors, among other things. And, going into an annual meeting, you largely know where the votes are going to come out after you engage with an investor, whether they implicitly or explicitly tell you. It is much harder, whether it's a raised eyebrow or a wink, wink, you don't really know how the investor is going to vote in the same way that you did before. And when then when that vote comes through and they see it on the report, they may not know exactly why, which is very different than I think in prior years.
All right, well, that was lively. Ali, we're gonna let you kick us off here on our next topic, which is shareholder proposals.
Okay. And I think shareholder proposals came up in a couple of different forms earlier today, but the other change coming through the SEC in early February was around the SEC no action process. So I'm just gonna be very brief on the change and then focus a little bit more on the implications. Essentially it's a revision or rescinding prior guidance. So, which was the SLB 14L, and then there was updated guidance. And what that meant is that we're essentially going back to the way it was before around the economic relevance rule, ordinary business exclusions, and then also introducing some additional focus on micromanagement, where that could also be brought that argument back into the process. So essentially what this means is, well, first of all, timing of this also is really interesting for companies and for shareholder proponents, because the proposals are submitted largely in the fall. That's where the submission window is. So in the fall, proposals were submitted. We were already under submission 30% below where we were in the prior year. Shareholder proposals have grown over the years in numbers very significantly. A good portion of that is because of everyone will just call anti-ESG proponents or proposal types that have kind of been added to the mix. And so, we saw an increase in proposals, a decrease in this fall. We also saw a decrease in support on shareholder proposals, on ENS shareholder proposals last year, pretty significantly than the prior years. I think while there's some probably political pressures in that, there are other factors as well, including that some of these proposals became much more prescriptive, and they were not going to get the support of shareholders in the same way that they did previously. Companies had expanded disclosures pretty significantly over the last couple of years. So some of those same proposals that once received higher support, receiving lower support. But anyway, all of that kind of coming into this new guidance, that means is significantly fewer shareholders being voted this proxy season. I think for a lot of investors, and for a lot of companies, that's not all investors, but some, they've voiced support for this because the voting process on shareholder proposals and the time that companies and investors have given to them has, especially ones that continue to receive very low support, was not necessarily viewed as effective. I don't think that's true of all proposals, but where we are now is fewer proposals, again, going into this year, fewer support. We're certainly seeing, and I think this proxy season is going to be really hard for us to assess exactly what the trends are, simply because some companies elected not to submit no action originally and didn't go back after the change in guidance. So we don't know how those would have played out. Some companies didn't revise their no action submission after the new guidance. And so the SEC was looking at those differently than the ones that did revise it. So there's some noise in this proxy season. And then we also have out there a lot of discussion around what's next. And so just very briefly, and in fact, the Business Roundtable yesterday had put some proposal out that around the proxy advisors and the shareholder proposal process that I think summarizes what we've been hearing, which is another reform to 14A8. eliminating really, and some like eliminating social type of shareholder proposals, raising the resubmission thresholds, amending the rules. So there are some proponents that are using the 14A4 instead of 14A8 process for shareholder proposals, closing that loophole. Things around co-filing and an appeal process for companies. So I guess what I'm saying is we've kind of hit this proxy season for companies and investors, a pretty significant change in the shareholder proposal process, and more to come. And then I don't know who wants to pick that up.
So I have a couple of, I would put a lot of money on the 14A8 rulemaking amendments hitting the proposal, but coming out this particular calendar year. And I think the number one target for the new SEC leadership will be the significant social policy doctrine as part of the ordinary business ground for exclusion. That's just been an incredible pain point for a lot of issuers. They've complained about it vociferously. That's going to be the number one target for the new leadership. In part, to build off of what John said, one thing that is, I think, different about the shareholder proposal community than what you saw 10 years ago is you are seeing a lot of conservative groups who are using the 14A8 process and basically mimicking pro ESG proposals, taking pretty much the same resolved language and flipping it on its head. And that has caused quite a bit of a problem for boards who feel now that they're in the middle of culture wars between the left and right and the 14A8 process is sort of the battleground for that. I've heard a lot of people have asked me, will the SEC get out of the 14A8 process altogether? And I really don't think so, because unless you are an extremely motivated company that wants to litigate and go to federal district court, the 14A8 process is a fairly good way of resolving disputes and a fairly low cost way of resolving disputes. So I think that you're going to see a 14A8 rulemaking that's targeted towards the types of things that Ali mentioned, rather than the Division of Corporation Finance getting out of the business altogether.
And we spoke up, so last year we did an exempt solicitation at Exxon, arguing exactly that point, that we thought the SEC was the best place to call balls and strikes as it relates to the shareholder proposal process. So I would agree with you there. And we've always viewed it as, pressure cooker or teapot, and the teapot lets off a little steam. And I think the shareholder proposal process has been used quite effectively, not always. And over many years, we have things now that we think are common good practice, governance practices that, 28 years ago when I started doing this were not so common. And it was not so uncommon that the brother-in-law of the CEO was the chair of the comp committee, and shareholders said, gee, that's probably not a great idea. And we had shareholder proposals around board independence and committee independence. I would agree that in the last couple of years, we've seen this back and forth between the left and the right and some of these proposal mills. But we do hope that the SEC will still be part of this process, because we think generally it has worked well.
And having led the staff that actually look at the no action letters, they're trying really, really hard and engaging with both proponents and companies as they're looking at these no action letters. And I got raked over the coals throughout my time at the SEC that we're being partisan, we're being political. These are really non-political career staff lawyers who are just trying their hardest and being put in the middle of pretty thorny disputes. So it's just not true that somebody there is behind the scenes thinking, oh, I like this kind of proposal and I don't like that kind of proposal. That's just not what happens.
So I will double down on what Eric just said, and I was there before the most recent tweaks to the interpretive guidance. So we inherited the prior administration's ones. And it still was really hard, even under that regime, to resolve close cases, of which there's always going to be some, because, and this is the one thing to add to what's already been noted, the institutional shareholder community who brings these for the most part, and there are a few gadflies who still exist, and they also bring them. They're dynamically working against whatever the guidance is. So it's not like they're going to keep bringing proposals they know are going to get knocked out under the new guidance. They're going to come up with new proposals that they think will go through that, or at least have a good shot at it. And so I think we're going to see a shift in the composition of the kinds of proposals towards things that are more squarely anchored on information disclosure as opposed to change in behavior, or information attached to things that are less obviously political in the partisan sense nature. But I don't actually think people sort of think, well, this is all going to go away. I really don't think it is under the new guidance. I think it's just going to change somewhat. It may go down a little in aggregate, but I actually think it's going to be with us for a while. Now, last thing I'd say, Eric alluded to the possibility of rulemaking. Now, rulemaking, if it actually is substantive and serious, could dramatically change the numbers. Here, I'll throw in just, parts of the administration are somewhat in tension with other parts. So one part of the current administration wants to really change the way all rules are passed involving OIRA, even in the SEC process, which it has not traditionally played a role. My current understanding is the proposal is they're going to get a 180-day review of all rule changes. And then at the end of that, if they have anything they don't like about it, it's got to go back again and then come back again and go back again. So if you thought rulemaking was slow under the prior administration or the prior administration or the prior administration before that, Republican, Democrat going back, the current non-SEC rulemaking proposal to add on to it is going to really slow it down. And then you've got litigation on the other end of that as well. So I'll just stop.
Yeah, I don't want to take us on a tangent, but one thing that surprised me, John, is the fact that the new administration made this new OIRA process early in the administration. It's going to slow down the rulemakings that they want to have go through. I mean, I would have thought that that kind of move would have happened towards the end of the administration, but
I too was surprised. I'm sort of pleasantly surprised because I suspect most of the changes they're going to propose I won't like on the substance. So it'll just take longer for them to get it done. But I do think the part of the administration that thinks that the independent agencies have not been sufficiently disciplined is more powerful than the part of those agencies that is appointed by the very same administration who wants to directly change the outcomes. I think they're more interested in systematic change than they are in any particular set of outcomes.
That was lively as well. Really, I was just going to say that it doesn't seem like it's the first time that the administration has a split personality disorder. Heard it's happened elsewhere. Eric, do you want to talk to us a bit about proxy advisors?
sure. So I'm going to talk about the proxy voting advisory business rule and subsequent litigation. Because I was at the SEC for a considerable portion of this story, if you notice, I'll probably not answer questions I don't want to. So I will then look at John. And since John was also at the SEC for part of this history,
Over there.
yeah, we'll just turn to Josh, and Josh will answer any kind of hostile questions on how the litigation actually played out. It'll be a lot of fun. So historically, companies have been, issuers, registrants have been frustrated with their dealings with ISS and Glass Lewis, and really felt that they weren't being able to have a good back and forth with the two proxy voting businesses. They weren't able to really get good responses from those two businesses. So at the end of Jay Clayton's chairmanship at the SEC passed a series of rules that essentially did a couple of things. They stated that the proxy voting advisory businesses are subject to the federal proxy rules. And they would qualify for an exemption to a huge swath of those proxy rules, but only if they satisfied two conditions. And those two conditions essentially broke down into the proxy voting advisory businesses would have to give advance notice of what their advice would be to the issuers. And number two, they would have to notify their own clients of what the issuer's response would be. I'm paraphrasing a little bit, but that's essentially what the two conditions were. So that rule, and I had to write all this down because this is going to get incredibly complicated. So if you're not taking notes for students in the audience, you really should, because the timeline here is a little bit convoluted. It will be on the exam, and I'm not going to have office hours beforehand. So immediately afterwards, ISS sued the SEC in the district court in the District of Columbia with a variety of challenges, including First Amendment challenges and challenges that this particular rulemaking was an incorrect interpretation of the statute that sets up that's the basis for proxy rules generally. Then the administration changed. Gary Gensler became chair of the SEC. And then in 2022, after notice and comment rulemaking, so after a proposal and after receiving comments, the commission partially rescinded the 2020 rules. So those two conditions that I mentioned, those were both removed by the new proxy voting advisory business. You may ask, well, so what remained? There was an important piece that remained even after the rules were partially rescinded, and that is that the proxy voting advisory businesses were still considered to be subject to the proxy rules. They were still considered to be soliciting proxies, and therefore they were subject to Rule 14A9, which is the anti-fraud rules that govern proxies. After that rulemaking, not surprisingly, the SEC got sued not once, but twice in two different circuit courts. So the National Association of Manufacturers sued the SEC in the Fifth Circuit, and the Chamber of Commerce sued the SEC in the Sixth Circuit, both claiming that the partial rescission of the rules was improper, in part under the Administrative Procedures Act. Basically, you can't flip-flop and partially rescind a rule that's never taken effect. Where did all of this lead? Well, it led to a nightmare for our Office of General Counsel in trying to explain where we are now. So in the Fifth Circuit, the SEC lost, and the Fifth Circuit found that rescinding the rules was indeed improper. The Sixth Circuit had the exact opposite conclusion and determined that rescinding those two conditions was proper under the Administrative Procedures Act. But perhaps the most consequential decision was what happened in the original litigation which ISS brought against the SEC. So in the district court in DC, the trial judge, the district court judge, found that the SEC under Chevron improperly interpreted what it meant to solicit under the statute, and that the proxy voting advisory businesses were not soliciting given the evidence that the SEC had in its initial 2020 rulemaking. That was shortly before Loper Bright, which, as everyone knows, jettisoned the Chevron doctrine altogether. So then we are now waiting for the DC Circuit to look at that particular decision from the district court. The same groups that sued in the Fifth Circuit and the Sixth Circuit intervened in the district in the DC Circuit litigation, and are now looking to review the district court's opinion that the proxy voting advisory businesses are not actually soliciting. Now note what I said about the timing, that was under Chevron. So under Loper Bright, the SEC is going to receive even less deference in terms of how they define what solicit means. So that's kind of where we are at right now. John, are you happy you are not SEC General Counsel anymore right now?
The moment I stopped, I was happy and I remain happy. I mean, just listening to you, I mean, like, that's the regulatory world we live in now, where maybe the rules in place, we're not sure. Maybe the conditions are still there, or maybe they're not. All of that remains up in the air. In the meantime, neither companies nor proxy advisors nor shareholders have any clarity about exactly under what standard, if there was a claim, say, intentional fraud by one of the information agents, could be brought, like how we would even think about testing that. And it's let me just say generally, let me go back to the prior comment. Add on a wire review before all that, and then test everything that comes out of that review. The bottom line of all of that is that the prospect of any kind of durable regulatory change over the next indefinitely has greatly fallen because of this. I mean, because litigation now spans administrations, which, if they switch party hats, means you've got radical change in policy, which then plays out. And we've already seen it, just to advert to something off our topic a little bit, but already seen it in the climate rule, where the climate rule is now the Eighth Circuit rule decided yesterday to put a pin in it until the SEC acts. But that was a discretionary choice by the Eighth Circuit, which we didn't know how that was going to turn out a week before that. So anyway, just to sum up, chaos is the outcome.
Can I just have a cheeky aside? Where were you on Wednesday, John? So I was moderating a panel at the Berkeley M&A conference, and we had 3 out of the last 4 general counsels there. Wonder which general counsel was missing when I asked, like, is the state of administrative law going to make rulemaking frustrating as all get out?
Did they all say it was going to be better?
I think they had different reasons for why rulemaking was going to be a nightmare, but Corner Post surprisingly was the consensus choice as the biggest headache. But anyway, I don't want to hijack your
I
panel,
wasn't
Josh.
there because Harvard is involved in a little litigation, so anyway.
Let me just ask, would anyone like to add anything on Post?
First, maybe we should just level set that Drew, Bob, and I all have passion, maybe critical passion, but passion for the proxy advisors, since we've all had roles there. And just for some context, I mean, Drew and I started many, many years ago. It feels like we're actually reverting to where we were when we started in this business at the Investor Responsibility Research Center, which is essentially ISS today. It was at a firm called Proxy Governance, which was put up to try to compete with ISS and Glass Lewis unsuccessfully for many years. Bob was at Glass Lewis, had a research and policy for many years. So I think we have perspective around, the practical side of this, all of the noise and, what that means. And I know, again, kind of going back to the business roundtable and what they're asking for, they're actually, for asking for Congress to get involved. There's a hearing next week or whatever it's called next week on this, if you want to talk about that. But I think our perspective from a practical standpoint is probably very different on the role of proxy advisors. The quality, we probably have different critiques on quality than I think are made in the public around it. And so maybe you want to pick on.
Yeah, I would just say a lot of times what's thrown out as like stipulated is the proxy advisors have more and more power. I would say they probably have the least power that they've had in 25 years. And I say that when I was at Fidelity 25 years ago, Fidelity was the largest investors, active manager, and the large index funds at that point were much smaller. And their proxy voting was generally to follow the ISS recommendation. And from a business standpoint, their perspective was, well, we are an index shop. We have no fundamental analysts. We're very few. We're a low-cost provider. We can't sell these companies. Why would we waste any money, so to speak, on making these proxy voting decisions? So the power of the proxy advisors at that point, in terms of over the index providers, then very different now, was significantly greater. And with the advent of Form NPX, The 40 Act funds had to disclose their votes. Before that, I was talking to a large mutual fund company in Boston, and I said to this woman, "Oh, how long you been in the proxy voting group?" She said, "Oh, I just got put in charge of it. Before I was doing this, the mailroom was opening up the proxies and signing them and sending them back." Right? So it's a very different atmosphere now. But like I said, BlackRock has 70+ people. They have sector specialists. So the idea that the proxy advisor's influence is greater now, just it's contrary to what has actually happened. And I don't want to disingenuously say there isn't some significant influence, but I would say it tends to be more about identifying areas of concern. Their recommendations may trigger an additional evaluation by the biggest investors, but their votes are really not driving the outcomes. However, John, to your point, I think you're right. The engagement is still going to be really important with the advisors. And what happens, the advisors usually like their engagements after they've talked to the investors, so they can say, well, what are you hearing from investors? So they may make some adjustments in response.
Nothing.
Yeah, at this point.
So let me get this straight. So I'm an investor. I invest in 50 markets around the world. I need to know how to get my ballot into the ballot box. I need some help with that at a low cost. I should be able to choose the vendor of my choosing. And I pay for the research, so I should probably read it before anybody else because I paid for it. And why does everybody keep getting in the way of that? Why can't these two firms collectively have revenues of under $500 million? They're tiny. I can vote in 50 markets on less than a basis point of my AUM by using these firms, and we pay for it. And don't I get to choose the people I want to hire to help me do my fiduciary duty? And there's a whole lot of people getting in the way of that, and we're really frustrated by it.
They're small. They are incredibly powerful, though. Like, and that companies are. I was not part of the SEC in 2020, but I think there is quite a bit of frustration in issuers in terms of, is the review cursory by the two shareholder firms, shareholder advisory firms, or not?
No, it's a fair point, but I would say they're only as powerful as the investors give them that power. And if there are gaps in the decision making, it's because the investors are choosing to follow the recommendations.
Well, I mean, we've talked about the rise of institutional shareholders, and it's true they have a lot of staff, but BlackRock also has a huge amount of assets under management, right? So, like, you're spreading an even big staff out over a huge amount of issuers. And if you're trying to keep your fees low, which there is tremendous pressure on asset managers to do, it's not like you can invest a huge amount of research and engagement with every particular issuer under your portfolio. So that's part of the reason that these two companies are influential. I mean, it's just their votes do sway asset managers, and they do sway institutional shareholders. So I don't want to like underplay how important they are in the system.
Yeah, and I think in the Russell 3000 last year, we had 25 same pay votes that didn't get 50%, and what, 50 directors that didn't get 50%. So I'm still searching for what problem are we trying to solve for if 95% of the votes are going in favor of management across the board. Where's this influence, or where's the harm? And I'm struggling to see that.
So again, I mean, I think I could very easily sit here and say what my critiques of the proxy advisory firms are. They're probably very different than the focus of this. I think the question Drew had, similar to 13DG update that we provided, is what's the ultimate goal here? I mean, the reality is, the analysis is probably a little bit flawed in that when you're looking at the influence in situations where everyone's sort of in agreement, right? So where you look at where a say on pay proposal, for example, failed, that everyone says that's alignment with the proxy advisors. I think that's alignment with a perspective. What we're not looking at is the noise. Investors have taken a lot of steps. I mean, Bob mentioned, BlackRock and the number of people they have. These stewardship teams have grown, and the amount of attention that they're spending talking to companies, getting the perspectives, clearly they're using the proxy advisory research and recommendations as an input. But I think in the instances where ISS, for example, recommends for, but an investor votes against, right? Those are not situations that necessarily get focus. And so I think there's all the noise. Also, I would just, this is my own view, but if the issue is around the recommendations, maybe the focus should be the recommendations, not to dismantle the rest of the services, the voting. I mean, what Drew was talking about is essentially the voting agent part of the of ISS and Glass Lewis, which, this sort of goes back to, is the ultimate goal for investors to not vote? And that might be, maybe that is, and then we're talking about something different.
So we all obviously have our own interest here, whether we were formerly in government, who we're representing now. So Josh, you're the only neutral party. What do you think?
Let's say off with their heads. I'm gonna defer. I'm gonna save that for an article. So let's turn to our last topic before we take questions. Drew, do you want to talk about executive compensation and sort of where we are? This final bring us home here.
Yeah, sure. So I'm having this conversation yesterday at Allie's firm, and I keep thinking to myself, and I don't think anybody in the room here who are lawyers and gets paid fees for this is going to like my comments. But if I ask somebody to give me a report on the pay of the top 5 people at my company, and you came back to me with a 60-page report, I'd probably fire you. It should not take 60 pages to describe the pay of 5 people. In addition to that, I think shareholders have wholly gotten it wrong on equity awards, especially around PSUs. I used this example the other day. Do we all remember who we voted for as the CEO of the 20th century? It was Jack Welch, right? We all voted on it. In 2000, he was paid $4.5 million grant date value. If I adjust that for inflation, in 2024 dollars, it's around $15 million. Well, the median S&P 500 CEO grant date value is $15 million. So the best CEO of the last 100 years would just be mediocre in today's pay. And I think we've just seen tremendous grade inflation. And I'm not saying we're not against people getting paid well. These are hard jobs. That's not what I'm talking about here. But the amount of time we spend writing about the pay of 5 people, the amount of grade inflation, and I think somebody Rob brought it up earlier, we put it in the proxy statement, it's only gone up. And every time we try to take a swing at this to tamp down pay, we seem to get it wrong. And shareholders have been part of that problem. So I'm not sure I have any great answers for that, but I'll start there and see if anybody wants to chime in.
Go back.
Well, I mean, we were, while I was at the SEC, we were working on a number and did make some progress on a number of fronts. So the pay versus performance rules were passed in about 2 years ago now. And that was, first of all, it was mandated by statute. So this was fulfilling the statutory mandate. It was supposed to give investors a more clear picture of what the relationship is between incentive pay and what the actual performance of the company was. Might require some tweaks. I do think if we're going to look at predictions again, I do think that the commission probably will look at the compensation disclosure and analysis provisions during Paul Atkins' chairmanship, but it's probably not in the top 5 or top 10 of rulemakings that he wants to look at. But CD&A and probably simplifying CD&A, which I'm guessing is not what you would favor.
I would.
You would? Okay.
100%. We could explain this in 5 pages. I've been looking at pay for years, and I would be perfectly happy with a couple of tables. Where I think the SEC could really help investors is, depending on the type of equity award you use, if it's a PSU, you don't have file form 4. So I can't even figure out what they're getting paid. In the summary compensation table, the equity award number is 15 months old. I don't know what the new awards are. There are some ways that companies could get us more current information on that. And I think that would be a tremendous help to investors And those are easy fixes in my mind. And so those are some of the ways I think the SEC could really help the investor community. And I think it would help. So think of it this way. If you had a bad year, let's say your stock was down 25%, the equity award that's listed in that proxy statement is 15 months old, and it might have been granted when your stock was up 25%. And just making that simple fix would put the alignment from board intention with what happened during the actual performance period would be a tremendous help to investors. So I think some small tweaks like that, but we don't have to throw everything out, but even a couple of those things would be very greatly appreciated by the investor community.
Yeah, the other thing I would add is the hardest thing for investors to understand is whether these awards are actually going to be earned or not. So you may see two companies, both with very high figures in terms of the estimated value, Black-Scholes or what have you. So one is earned and one is not, but at first blush, to kind of Jude's point, you see that most recent disclosure and it seems like they're equal and you compare that against performance, but 3 years or 5 years hence, when you realize, geez, some of those awards are only earned at 30%, others were earned at 150%. That is the most valuable information because it really goes back to the pay for performance. And that's where some of that disclosure is essential because the initial grant amounts may be very different from what's ultimately earned.
Well, I'm going to tie these two topics together because this is an area where I think the proxy advisors could actually do a lot better, which is the pay for performance analysis. Some of that is simply based on the disclosure rules and how they're bringing that in. But I think to Drew's point, there's lagging disclosure, a lot of interpretation of rules over the time. So even for some companies, the disclosure is 1.5 years. It's not even just that prior year, but based on how they evaluate performance, it's pretty old. And I think the pay versus performance, like the reality is the new disclosures aren't being used by investors or the proxy advisors in any real way today. Maybe that will change over time once we have more years with them, although I do think there's probably some changes coming, at least maybe not a priority, but at some point. But I think that whole granted versus realized is a real issue. And obviously you're not going to know when something is granted unless you're not making it long-term performance based, which is another area up for debate. But you're just not going to know. And so I think you have to have a model that looks at both of those. And we don't really, that's not really in place today.
Do you think it's possible that the new SEC or Congress does away with say on pay? Has that been mooted at all as a possibility?
I mean, I think it's definitely on the hit list for at least some members of Congress. Like, I think it's extremely unpopular with some companies. It's when you're dealing with Congress, you're dealing, I think, with a different kind of potential logjam. There's only so many bills that they're able to actually get across the line. And, you know, one way that they often break the logjam are very, very big pieces of legislation with lots of stuff stuffed in there. But it's definitely something that some issuers do not like quite a bit.
But so two things on that, similar to pay versus performance, it's mandated, right? Sam pay was mandated. That's, I mean, because companies were, I mean, the reason, I mean, Sam pay is kind of interesting. It came in talking about shareholder proposals. It was originally through shareholder proposal mechanism. Companies that were having issues with directors receiving high opposition due to compensation committee members receiving high opposition due to compensation issues voluntarily adopted say on pay. And then it was mandated. And so you took that burden off of the director compensation committee member and put it over on say on pay. So I think there are companies that don't like it. There are other companies who've been through cycles where I think they feel like they've kind of learned to deal with it.
I wouldn't disagree with that, right? I was careful. I did say some companies. It's on the hit list. It's on the hit list of all companies. So
No, we're never going to be able to represent all companies, right? I think fair to say.
well, I would like to represent all companies. My company, I think I'll do great in terms of my partner review at the end of the year if I get all companies represented.
Yeah, I mean, my take just is going to synthesize what was just said. When Congress has managed to actually pass legislation in the areas that we're talking about largely today, it's where a coalition of different interest groups have come together. The Jobs Act is a nice example where they're not really competing with each other, but they're building each other's political interests to a level that can actually then get through. What you're just talking about is where they're divided among themselves, which then means it's not happening, right? I don't think. I just don't think that legislation is likely. I mean, on the broader issue, I'll confess something. I'll get thrown out of the Democrat Party of the corporate governance community, but I've never understood the amount of attention that people try to bring to this overall process, the compensation. And the reason I haven't understood it is because whenever I have had to lean into it for a given company or a given executive, given the dynamics of hiring, promotion, incentives, and the like, I have never found it at all obvious what the right answer is. I've always felt an incredible range of reasonable judgment about how to think about what the best package of incentives are in that moment for that executive, benchmarked against his outside opportunities or hers, which are often invisible even to members of the comp committee of the company. And so the idea of trying to write comprehensive guidance, even much less rules to lean into this area, has always struck me as a bit of a will-o'-the-wisp. I'm not against more information if it were free to produce, but of course it's not free to produce. And that's the point about excessive pages and a lot of devotion to all this. And so if I were czar, this is never going to happen, just to be clear. So as a political prediction, this is completely empty sentence about to follow. But if I were czar, I would wipe away everything we've got now and I'd recalibrate and I'd get people to boil down what are the, as you said, 5 pages of most salient general information, and that would then be mandatorily required. And then have, I would probably go back to the shareholder proposal process in this area and allow that to be tailored to specific industries or companies to augment the 5 pages. So if you don't like shareholder community, the way those 5 pages work for that company, fine, come up with a specific, and actually here, again, you can tell this is totally just me making stuff up. It'll never politically happen. I'd be in favor of micromanagement in that one area. Like if you could show me that Vanguard in the room, BlackRock and others all came together for that issuer and said, actually, what we really want is a quite detailed thing on this particular piece of compensation. Why would the SEC want to block that under current structures? That could never be brought. That shareholder proposal would get kicked out. It wouldn't be allowed in. And so we actually get in the way of that kind of dialogue. I'll go back. I was being a little backwards earlier. I just want to say, I actually think the 13D intervention is incredibly bad. If it wasn't clear earlier, for this reason, that it gets in the way of that kind of communication from a portfolio manager, for God's sake, not some career risk corporate governance official, but from a portfolio manager to not be able to tell a portfolio company IR representative, we think your comp package is totally out of whack for what you've got in your company. And yet that's where we are right now, where that communication is greatly chilled. I'll stop.
I'm going to take one dissenting view here from the rest of the panel. Like I'm all for simpler and clearer disclosure, but it's really hard to write it. And if it's hard to write that kind of disclosure, it's really hard to write the rules to get to that kind of disclosure. So, I mean, the simplest disclosure that we worked on while we were at the SEC were checkboxes. And checkboxes became the bane of my existence after the rules were passed, because you're essentially trying to boil down a lot of complicated information into a binary yes or no. And the amount of lawyer questions that we got on checkboxes was just unbelievable. So, I like the idea of simpler, more decision useful information, but it's hard to get there. It's hard to draft it, and it's really hard to write the rules to get people to draft that kind of disclosure.
Yeah, I think I mean, in fairness, you see that kind of disclosure in those instances where ISS and Glass Lewis, for example, are against you, and then you see a supplemental
Yeah.
letter that actually
It's really
tells
clear.
the 5 pages that Drew's actually looking for.
Well,
So
look,
interestingly enough, it probably sort of, I don't really have a view on the right disclosure. But my point is, I think I think you end up with the answer that you want only when there's a problem.
Yeah, I mean, there's a common theme between a lot of these areas. It's engagement is good, but it's hard and it takes a lot of time. And no matter which side you're on, whether you're an issuer or whether you're a shareholder or whether you're a proxy voting advisory business, you're under a lot of time pressure to get a lot of analysis and a lot of engagement done quickly. But if you cut corners and it's well, I kind of like that. Like, I mean, that's not particularly useful for the people whose money is actually being put at use.
All right, so we have enough time before our reception to take any questions that folks have. So if you, yes.
So, I good to see you all. I'm Cory Cover. I was at the PCC previously with both John and Eric. It's kind of like a big picture question, but in terms of changes in this current administration, I mean, it was interesting. A lot of you call the 13DG change a rule. And it's not a rule.
Yep.
It was a change made to like the last page of a frequently asked question, and there was like a red line, no press release, no public comment. It was just done under the dark of night by staff with no attention drawn to it or review or commentary. So two things. One, I mean, the OIRA change that you guys talked about, OIRA getting involved in the rulemaking process, will that also interfere with deregulation, right? Like you can't deregulate. So it does seem like hopefully and probably there will be at least a regulator, maybe overuse the term, but like to slow down deregulation. And then separately, is this all just going to drive us further into the non-rule rulemaking guidance and updating Q&A stuff that has these much greater implications? And where will that lead us?
Can I start? So yeah, there's a tremendous amount of guidance that was issued by Acting Chair Ueda before Paul Atkins ever got sworn in. I mean, just a real wave of guidance. And I was, joking with Megan Barbaro on Wednesday, like you wouldn't have let me do that. I think that the way administrative law ought to work is it ought to apply to everyone equally, whether you're passing a rule, whether you're repealing a rule. But, practically speaking, like the big question is who's going to sue, who's going to have standing, who's going to complain about any particular rule. So it's not, even if it's supposed to be even-handed, in practicality, like, you don't have an even playing field in terms of who is complaining and who is litigating.
So I'll add, I mean, you implied your question. I think it's completely astute. I do think the trend towards more litigation about all rulemaking, coupled with the partisan split in the circuits, so that if you want a Republican judge, you go to the Fifth Circuit, and if you want a Democratic judge, you go to the First Circuit, and if you're not sure, you sue in multiple circuits. Coupled with the OIRA change, and just for those that they're not everybody in the room, I should have unpacked that earlier. OIRA is a separate branch of the executive that sits under OMB that basically for executive agencies for a long time has played an important role in creating economic analysis for the agencies that don't have economic expertise. The SEC has economic expertise, as does the Fed, as does the FDIC, et cetera. So they traditionally were not understood to need OIRA to do cost-benefit analysis. Now, all the agencies, including the SEC, have to run rules through OIRA too. So they have DERA at SEC doing 6-month-long economic analyses, and then they're going to turn it over to less trained non-financial economists who are generalists in the economics field, who are going to redo their analysis over a 6-month period, which only obviously creates opportunities for second guessing, disagreements about judgmental inputs, politicization, et cetera. So it's going to both not only slow down but make less predictable the path towards getting any kind of rule change. And that's whether you like deregulation or more regulation or something in between, right? And then finally, yes, to tie it out, because of that, in expectation, no head of any division is going to say, oh, I know what I want to do. I want to write some rules. No, they're going to say, I want to give a speech, or I want to write an informal guidance document, or I want to have staff look for the gray spaces where we can do things without going through a formal rulemaking. And so the net result of all that, it actually is worse rule outputs, no matter, again, where you are on the pro or anti-regulatory side. So I think I've long been concerned about this. This is a long-term trend. I don't understand why Republicans don't get this. There is a little bit of, final point, a little bit of asymmetry in favor of a anti-regulatory stance built into this, because it's easier to deregulate through guidance than it is to regulate through guidance. But it's not impossible to regulate through guidance. We did it for SPACs. There was speech, and we pointed out some
Hey, you're
problems.
that guy.
I'm that guy, yeah. And so actually Republicans, I don't understand why they don't see these points.
Oh, they do. They ask me about your speech quite often, John. Like, I think they get it.
No, but they don't see the points at a meta level about the overall regulatory process.
Well, I
To
think
your point earlier, why did they self-impose a WIRA right now?
I don't get that. I mean, the number one question that I get in client meetings is, how do we protect ourselves? Like, after I explain what I think the new administration is going to do in the securities field, the number one question or response is, well, how do we prevent ourselves from being whipsawed, so that like 4 years from now, 8 years from now, 12 years from now, we're not spinning our wheels? And I think the kind of too easy and too glib reaction to what you just said is, well, maybe this is good news, right? Because you're just going to have, if there's going to be less regulation and less deregulation, you're going to have much more predictability. But I would agree with you. I don't think at the end of the day that this is going to yield more predictable results. And the other thing is that this is not happening in a vacuum, right? So you're seeing minority commissioners being fired. You're seeing a challenge to Humphrey's executor. There's lots of things that are going on in the administrative state. And if you're layering this on top of potentially not having minority commissioners going forward, I think it's really, really hard to predict like how administrations are going to behave for 12 years from now. So this is going to get, I think, much more harder to predict and not easier to predict.
Let me just real quick, cashing out crypto. You know, a lot of the money that put the president where he is comes from that would-be industry. They want to be bigger. The only way it gets bigger is if there's rules passed, because the current state of securities law hangs over that industry into Aurora with lots of pending and bad cases at the margins. And so even though you've got guidance coming out of the interim chair that has loosened up the reins a little bit, they're never going to be able to have really what they want. Coinbase is not going to get what they want until they get rules passed. And to get rules passed now, you've got a much longer, more difficult process. And the same thing is going to keep happening over time. There are going to be areas where both parties want the regulatory process to work better. And right now, I think, if anything, it's getting worse.
Not optimistic.
Yeah, can I ask a question or to former SEC? So the staff guidance, thank you for making that clear. I think the interpretation of it is a rule, regardless of whether it's a rule in terms of like how it's interpreted but how often would a SEC revise its revision? Meaning if, Paul Atkins comes in and it's like, what have you been doing before I got nominated? I wouldn't make some adjustments.
You can do it a lot easier if it's guidance, kind of if it's a notice and comment rulemaking. If you're doing notice and comment rulemaking, you're looking at least 2 years to actually change a rule. But guidance can go back and forth and back and forth. So the guidance that you mentioned on 14A8, the staff legal bulletin 14M, that was essentially overturning staff legal bulletin 14L. Right, which started, which was the staff put out right when I joined the division in 2021. So, that's an example of if guidance is going back and forth and back and forth, it's a lot easier if you're in the administration to get things done quickly, but having it durable, predictable, long-term, sustained, like that's not what guidance does.
No, I get that. It was more about if there's guidance that
Clarity.
sort of creates some lack of clarity, will they go back and kind of revise it to?
Oh, yeah, sure. Like we do, like the staff would do that all the time. And sometimes, you would get a compliance and disclosure interpretation and it wouldn't quite yield the results that you thought it would. I mean, to give you one example, when the cybersecurity rules came out, the staff and I were working really, really hard to get a lot of staff statements out there, a lot of division director statements, a lot of CDNIs to try to provide that clarity real time as a rule was being implemented. So there are some advantages of guidance, right? If you're trying to answer tough questions in terms of how a rule applies, there are some good aspects of guidance too.
There's a question in the back.
Yep.
Yeah, just had a question, if anybody's willing to speculate on where the 13 DG guidance came from. Eric, you said it was maybe about ESG, so how exactly? Is it Commissioner Ueda's into the common ownership theory? Is it someone told me it had been kicking around Corp Fin for a while? Maybe you can address that. It seems like a strange thing.
So, I mean, guidance is, there's commission level guidance and there's staff guidance. And this was staff level guidance from the Division of Corporation Finance. But the staff do pay attention to what the chair and the chair's council are thinking and saying. So, and then you did see Acting Chair Ueda make several statements in favor of the guidance, and particularly noting what its implications would be for ESG activism. So I think if you connect all those dots, you can see. I think you can see sort of where what more of the intent probably was.
Question? Well, that was quite the afternoon, so please join me in thanking our panelists. And I have been asked to announce that we have a reception in the annex, the Jerome Green Annex, beginning now. To get to the annex, you basically exit the building and take a left. So go out the main doors of the law school, take a left, and then you'll see a gate on your left. You go through that gate and you will land right at the annex. We look forward to seeing you there.